Hello, everyone. My name is Freda Schneider from the JCC, and I want to welcome you all to our next edition of the IdeaFest series. Tonight's broadcast is entitled Appointed for Life. Brighton Town Judge Karen Morris joins us, along with New York State Supreme Court Judge John Ark and attorney Sharon Stiller, who will explore the politics and procedures of selecting Supreme Court judges. Leading our panel tonight is Judge Morris, Brighton Town Judge for 26 years and full-time professor of law at MCC. Throughout the presentation, if you have any questions for our panel, please do use the Q&A function at the bottom of your screen, and we'll take questions at the end of the presentation. I thank you very much for joining us this evening and hope that you enjoy what is definitely going to be a very stimulating and certainly timely conversation.
Great. Welcome, everybody. Thanks for joining us to explore the operations of the United States Supreme Court and the politics and the procedures for selecting the Supreme Court judges. We have a panel tonight. So the other two members of the panel, first is Sharon Stiller. She is a former assistant district attorney and currently a civil litigator. She chairs the employment group for the law firm of Abrams Festerman and also chairs that firm's Rochester office. Abrams Festerman is a full-service law firm with offices in Rochester, Brooklyn, Long Island, and White Plains. Welcome, Sharon. And we have Judge John Ark, who has served as a New York State Supreme Court judge for 26 years, following 14 years as Brighton Town Judge. He presides over cases with great impact on people's lives, such as medical malpractice, mesothelioma, land use, divorces, and over 20 homicides. Our plan for this hour is that each of us will talk for about 10 to 12 minutes, and then we look forward to your questions, and we hope we'll have some answers for them. I'm going to talk about the role of judges in the courts. Sharon's going to talk about the selection process of U.S. Supreme Court judges, including the politics of it all, and recent confirmation hearings, and also the impact that judges have on lawyers. And Judge Ark is going to talk about the issues related to elected and appointed judges, which is what are the pros and cons of each of those methods of selecting judges. Also, he will address how and for what judges are disciplined and when can a judge, if ever, be removed from the bench. So once more, my topic is the role of judges and the courts. So what exactly do judges do? Clearly, they play a critical role in our society. They decide many of the important societal issues, such as abortion, same-sex marriage, legality of the Affordable Care Act, issues surrounding absentee ballots, close elections, who wins, how broad is the government's power to protect health in a pandemic, can the government mandate the wearing of masks, can the government limit attendance at church services, are transgender workers protected against discrimination by their employers? Are immigrants who were brought to this country as children entitled to remain here? Must asylum seekers from Mexico wait in Mexico for US court hearings? Were Defense Department funds illegally diverted to build Trump's wall on the Mexican border? All of these are issues and many more that need airing and need resolution. And this is the role of judges in the courts. There are three main types of decisions that judges make. The first is to decide factual issues at trial. For example, was the light red or green when the motorist went through it? That could be a key issue in a case. That's one type of decision that a judge makes. Another is to clarify the meaning of statutes. Legislators do not always make their statutes clear, and interpretation is needed. So for example, police can arrest when they have probable cause. What is probable cause? Do facts in a case add up to probable cause? That's something that a judge needs to decide. There was a statute that said that it was illegal to use profanity in a public place. Well, suppose you use profanity on a porch that's an open porch, not enclosed. Is that a public or private place? Somebody has to make that decision because that's going to impact the outcome of the case. And it is judges that make these decisions. Another one that I thought was really interesting involved the circumstance when Uber first wanted to come into New York City. The law in New York City says only yellow cabs can respond when somebody hails a cab from the street. That was the term in the statute. So the yellow cab drivers wanted to keep Uber out of New York City. They argued that when we solicit an Uber driver on our phones, we are hailing a cab from the street. And of course, Uber argued otherwise. Somebody has to determine if that getting the Uber driver with your phone is hailing a cab from the street. Because if it is, then Uber can't come in, only yellow cabs can do that. So it was a court that had to make those decisions. So they judges clarify the meaning of statutes. And in that case, the court held that the hailing a cab from the street was something different than soliciting an Uber driver, which opened then the doors of New York City streets to Uber drivers, much to the unhappiness of the yellow cab drivers. And a third type of decision that judges make is interpreting the Constitution. So they decide factual issues, they clarify the meaning of statutes, and interpret the Constitution. The Constitution is broad. It gives us ideals. It's gray in the interpretation. Somebody has to interpret it, and that's the judge's role. For example, was separate but equal a sufficient accommodation of equal protection? This is an issue somebody has to decide. Does the right of privacy in the Constitution include the right of a woman to have an abortion? The Constitution, of course, doesn't address abortion. This is an issue that judges decide. Equal protection and the pursuit of happiness, are they broad enough to include the right of same-sex couples to marry? This is another issue that judges have to decide. Can the president pardon himself? There's another question that may come up. How do judges decide these issues? So the first thing that a judge does is look to see if there's a precedent, if there's a prior case that addressed the issue in question. If so, there is a rule of law called stare decisis that requires that judges follow the precedent absent some good reason to change. But as a general rule, the judges are to follow precedent, and that's to give us consistency in our law. And of course, decisions of the United States Supreme Court are the ultimate precedent. Here's an example of a application of this stare decisis. I, as town judge, sometimes will have before me a case involving a driving while intoxicated charge that resulted from a roadblock. The roadblock seems to be in contradiction of the concept that a police must have at least reasonable suspicion to stop a vehicle. At a roadblock, everybody who goes through that part of the road gets stopped. So somebody raises the question that the stop at the roadblock violates their right against unreasonable searches and seizures without probable cause. It's unreasonable for the police to stop them. I might think that's a good argument, but the United States Supreme Court has ruled otherwise and ruled that those roadblocks are, if they're done properly, are constitutional for two reasons. One, the stop, assuming no evidence of a crime, is minimal, momentary. And two, everybody has to be treated equal. The police can't stop just some cars. They must stop every car or every third car or every fifth car. And as long as the police follow those rules, the United States Supreme Court has ruled that those roadblocks are constitutional. So now if somebody in Brighton Town Court raises the issue that the roadblock is unconstitutional, stare decisis says to me, I may like your argument, but I must rule that the stop was constitutional and therefore the charge will go forward. So when there is no precedent, how does a judge decide a case? So now a judge is going to look at what in his or her decision is the fairest, what decision coincides with public policy, what are society's values applicable to this issue. But those, I submit, are sort of squishy issues, and they individual views of judges can find their way into our law by their decisions when there is no precedent. So who are our judges, and what do they bring to the job? What values and mindsets and philosophies and leanings all are very important because they can find their way into our law. Let me, I don't want to take more time. Let me just note there have been 8 Jewish judges, some very great ones. Louis Brandeis from 1916 to 1939 was a standout judge, as was Benjamin Cardozo, who served only 7 years but wrote some very important decisions. Felix Frankfurter served for 23 years. Arthur Goldberg was 4 years only, also served as U.S. Secretary of Labor and U.S. Ambassador to the United Nations. He was involved with 2 very important cases. He served from 1962 to 65. He was part of the Brown versus Board of Education majority, and also wrote the decision in a 5-4 case of Escobedo versus Illinois, which held that criminal defendants are entitled to lawyers, not just at trial, but also from the beginning of the arrest, and as well as prior to the arrest when they become subject of an investigation. So those were very big decisions. Other Jewish judges, Ruth Bader Ginsburg, of course, alas, served from 1993 to 2020, and 2 currently on the bench, Stephen Breyer, who was appointed by Clinton, who's now 82. I wonder if he was waiting for a Democratic president to be elected, hoping before he stepped down. And Elena Kagan, also currently on the court. So that's how judges go about making decisions and the important decisions that they have to make. And with that, I will pass to Sharon, who once more is going to talk about the selection process, the politics, and the impact of judges on lawyers. Sharon.
Thank you, Karen. That was fascinating. So I'm going to play a little bit onto what Karen talked about, particularly talking about interpretation. But before I start talking about selection and interpretation of the instructions given to us about how we select judges, I just want to spend a minute talking about separation of powers, because when we talk about what the judiciary is, and when we talk about what the United States Supreme Court does, what we're really talking about is separation of powers, the legislative power, the executive power, and the judicial power. And we have seen significant emphasis, I think, on the different roles that each of those branches play. So with that, I want to get to how we select and what instruction has been given to us and what has been done with it. And that's really difficult because, as Karen said, we judges interpret laws. When we talk about selecting United States Supreme Court judges, what we're talking about is a little tiny phrase in the Constitution called the Appointments Clause. And it's in the United States Constitution, Article 2, Section 2, and it says, the president shall nominate, and by and with the advice and consent of the Senate, shall appoint judges of the Supreme Courts. That's it. It doesn't tell us how many. It doesn't tell us particularly when. It doesn't tell us how. So when Karen talks about interpreting laws, this is one of the most important laws that has had to be interpreted or given voice to over the years. And we really saw that, I think, in the, we've seen that a lot lately, but we saw it in particular with the selection of Amy Coney Barrett. And the question of, does a nomination just get run through the Senate? Is there more for the Senate to do? The Constitution doesn't tell us that. So it's really up to the society and up to the Senate to decide how to handle that. So clearly the Senate has an advisory role. Does that mean just approval? Some say that the Senate's advice is not binding, but we know that, for example, in 1987, some senators rejected President Reagan's possible nomination of Robert Bork, and he nominated him anyways, and then had to withdraw the nomination. We also know that historically, the Senate has given a lot of respect to the opinion of the senator from the state in which from which the nominee hails. So those are a couple of concepts that have occurred, but there's nothing that says that exactly what role the Senate takes. There's nothing that said that the Senate had to have hearings with respect to the issues concerning the sexual misconduct allegations and things of the sort. So it's an open-ended issue and continues to be an open-ended issue, and different rules may apply at different times. A couple of other things. We always think that United States Supreme Court judges have to be lawyers. There's nothing in the Constitution or the law that says that they have to be lawyers, but everybody has been so far. However, two of the judges did not attend law school. So James Burns, who was on the bench from 1941 to 1942, did not even graduate high school. He taught himself law and passed the bar at age 23. Robert Jackson, who came from the same law school that I went to, Albany Law School, and is a big hero at Albany Law School. He didn't attend college, but you had to, he attended Albany Law School. However, you had to be 21 to get a certificate after you attended law school. He was only 20 because he was so brilliant. And so he did not theoretically graduate from law school. Later on, he was given a certificate. One of the questions, and we'll get to the questions that you're asking, but one of the questions talked about political or ideological views. And, we always think it's great to have somebody, to have a majority on the bench who parallel our ideological views. That doesn't always happen. But it is permissible for presidents to appoint and the Senate to somebody to be appointed who shares the president's political view. Interestingly, as I was preparing for this, one of the things that I learned is that the majority of the appointments in the past decades have been Republican appointments, and the number of appointees in a president's term goes from a high of 9 appointments during Roosevelt's term in 1933 to 45, 5 for Eisenhower's term, and 0 for Carter. So it really depends kind of on the luck of the draw. We'll talk about some of the situations that exist with respect to that in a minute. three top criterion for appointment is generally political or ideological views, professional excellence, and integrity and impartiality, which is always an issue because if anybody listened to the hearings, you know that judges are not allowed to comment on what they will do in the future. So there's judgments that are made on issues that are, to use Karen's term, squishy. The candidate is evaluated by the American Bar Association Standing Committee on the Federal Judiciary. Almost everybody goes through the Senate Judiciary Committee. There's a private background investigation by the FBI, and the president can consult with anybody else that the president wants to, including, for example, the sitting justices. The speed of appointment varies from, I think, a record speedy appointment, Amy Coney Barrett, which was 7 days after Ruth Bader Ginsburg's death, to an average of approximately 20 days. And there are also sometimes issues about appointments, recess appointments that occur when the Senate is in recess. One of the questions that I think we'll be debating is term limits. And I know John's going to be talking about that a lot more. But I want to give you the phrase that I think is a critical phrase. And presidents are often known by the judges that they appoint. It's a critical issue. Alexander Hamilton in the Federalist Papers said that while the judiciary is always in danger of being overpowered, nothing contributes as much to its firmness and independence in office as its permanency. So while there are maybe a tendency to perpetuate a certain thought by having people in office for a long period of time, there's also a freedom that comes with it that Judge Ark will talk about more. When I talked about presidents often being known by their appointments, one of the best things that John Adams did, for example, in 1801 is to appoint Chief Justice John Marshall, who served 34 years as the Chief Justice and really formulated the concepts of judicial power that we have today. One of the questions that we were debating as we were preparing this last week was, how do vacancies occur? What is a Supreme Court justice? Is there a 25th Amendment for a Supreme Court justice? And the answer is that Supreme Court justices hold office during, quote, good behavior. And, who knows really what that means. So they can be thrown out of office, similar to presidents through impeachment. That has only happened once. There was an impeachment vote in the House for Justice Samuel Chase. It was strictly a party matter. He had opposed Jeffersonian politics, and so he was impeached, but the Senate acquitted him. There's no power for a president. Let's say a president appoints a Supreme Court justice, and he appoints that justice because he believes that that justice is going to advocate a particular judicial philosophy, and that justice doesn't. The president can't say, whoops, I made a mistake. I have a liberal on the court when I really intended to appoint a conservative. So the president has no power to remove a justice. 42% of the vacancies on the court occur because of death. Sometimes people retire. There have been 2 resignations in office. Karen actually mentioned some of these people, but Abe Goldberg resigned to become a US ambassador to the UN in 1965. And in 1969, Abe Fortas resigned after criticism of his speaking engagements, and he failed to be appointed as the chief judge. In 1939, there was also a change in the law so that judges can retire due to disability, which I think is an important thing. I talked before, I'm just going to mention briefly politics. We could talk forever about it. First of all, politics can determine the number of judges on the court. There's nothing in the Constitution or by law that says that there have to be 9 judges. And initially, the first Judiciary Act in 1789 set the number of judges at 6. That changed over time. There's been a low of 5 and a high of 10. And we can talk about it more later on. It is possible to change the number, but the question that I would ask is why? And does that open the door then to changing the number anytime we don't like the complexion of the court? If we don't think there's enough women on the court, do we change the number so that a sitting president gets to appoint more women, things of this sort? I mentioned before the inability to know what you're going to get, and I'd like to give you one example of that, which is Eisenhower, when he appointed a number of judges, appointed Earl Warren, who was a Republican, who he thought would be extremely conservative. Earl Warren was the backbone of the Warren Court that made major inroads into protections for individuals in criminal law. I believe the Escobedo case that Karen mentioned occurred during Warren's tenure as chief judge, and so did such important decisions as Miranda that we've all heard about, Miranda rights. I'm just going to give you, because I'm kind of exceeding my time, one other illustration of that you really can't tell what you're gonna get when you appoint a judge, because cases are complex, and it's not, do you favor abortion, don't you favor abortion, do you favor protection for transgender individuals? It's just much more complex than that. And as a lawyer, and particularly doing what I do, which is often employment law, and most of my practice is employment law, what the United States Supreme Court says on a particular issue can be critically important. What they say on issues like arbitration is critically important for me in my practice. My practice is much more involving things like arbitration because of that. But as a person, there are other issues and other protections, freedom of speech, things of the sort that are important to me. But honestly, the role for ordinary citizenry, most lawyers, the role of trial judges, the kind of judge that Karen Morris is, the kind of judge that Judge Ark is, probably touches more people on a day-to-day basis than being a United States Supreme Court judge. Yes, you have a tremendous amount of power. You have the power to assure our democracy, which is a critical power. But in terms of touching people's lives, there's countless people that Judge Morris and Judge Ark has touched their lives. Just one more example, and then I'm going to turn it over to Judge Ark, and that is Neil Gorsuch. So when Neil Gorsuch was appointed to the United States Supreme Court, the belief was that he was appointed as a conservative, about as conservative as one could get, a match for Judge Scalia. But he wrote the opinion in a pivotal case that I think is a fascinating case that I've been following. And I'll tell you why. And really why is because the philosophies that judges use to decide cases are much more significant, much more probing than the simple phrases that we use in our ordinary life. Do you believe in abortion? Don't you believe in abortion? Do you think we should protect transsexuals? And what the courts are required to do, as Karen Morris mentioned, is to analyze real cases. So there's a case called Zarda versus Altitude Express, and it involved a guy who was a skydiver who was terminated after he revealed his sexual orientation, and there's lots of interesting aspects to it. But the question that reached the United States Supreme Court was whether Title VII, which was enacted in 1964, 1964, and provides protection for or against discrimination based on gender, whether that covered sexual orientation. And there was a companion case that raised the question of whether it covered being transgender. For approximately 50 years since Title VII was enacted, the courts had said, no, it didn't cover it. The lower courts had said that. And Congress had declined to expand the protection from gender or for gender to sexual orientation and to transgender. I listened to the oral argument in the case, and I could tell that Gorsuch was troubled by that. And his philosophy basically was a law means what it says. And he wrote a decision, the majority decision in the case, that said the law covers gender, and transsexual and sexual orientation are plainly gender. So you can never tell what's going to happen. It's a fascinating, fascinating issue. And I greatly appreciate having had the opportunity to discuss it with everybody today. And we welcome questions after Judge Ark is finished with his section.
There, thank you. Can you hear okay? Well, a couple of things I just want to address quickly. First of all, there's always an issue, with, obviously not with the U.S. Supreme Court, because those are appointed by the president and confirmed by the U.S. Senate. But for a large part of the judges throughout the country, particularly trial judges, there's always an issue of whether judges should be appointed or elected. In New York State, most of our trial judges are elected judges. Both Judge Karen Morris and I had the opportunity and the privilege of being elected Brighton Town Justice. And I think between the two of us, we've been elected 11 or 12 times. And as a Supreme Court judge, I was elected twice. There's benefits and drawbacks to either process. I happen to believe that, particularly with the importance that judges play in our communities, that the largest number of people should be involved in the selection of that person or people who serve as judges. And you get that best by an open election. At some point, somebody has to make determination as to who a judge or who will serve as a judge. Now, obviously in the U.S. Supreme Court, it's the President of the United States, subject, of course, to the confirmation process. But on a local level, and these are the judges that really are involved in your day-to-day lives, I happen to think that the community should have import into that determination. The net result is that I think in the long run, you'll get a more moderate type person who is an elected judge, because they have to appeal to the electorate as a group, as opposed to an appointed judge who could be just serving at the whim of the political leadership in a given community. As it so happens now in Monroe County, we have it used to be, if you were a Republican, you had an advantage in running for countywide, and now there's probably an advantage being a Democrat. Point being, though, that whoever runs, you have a couple 100,000 voters making that determination. And that shines light onto the person's background, character, and reputation. The issue of disciplining of a judge, in the federal judiciary, where the judges are appointed, the reality is the only way a judge can be disciplined and removed is through an impeachment process. And it's somewhat ambiguous in the Constitution as to whether or not uh, judges can be impeached, but they've gleaned from that they're public officials, federal public officials, and therefore can be removed by the impeachment process. There's only been one U.S. Supreme Court judge who's ever been removed, and that was Salmon Chase in 1804. And the basis for which he was removed was really a political judgment, which in reality, most impeachments are. In New York State, we have a much more rigorous process for removing a judge. We have what's called a Commission on Judicial Conduct, and it applies to local town and village justices. It applies to county court judges, Supreme Court judges, appellate judges. And the way the process works, if there's a wrongdoing or a claimed wrongdoing on the part of an individual who's serving as a judge, a complaint can be filed with the Commission on Judicial Conduct, which is a commission of, I think it's 15 lawyers and other judges that hears the complaint. They may take testimony if necessary, and they'll make a determination as to what the measures should be taken after they've made a finding. There could be a letter of reprimand, there could be a letter of caution, there could be a censure, or there could be a removal from office. Unfortunately for our community, a couple of years ago, one of our local city court judges had to be removed from the city court. And one of the ramifications of that is if you are removed by the Commission on Judicial Conduct, that you can no longer serve as a judge in any capacity in the future. Of course, the determination of the commission isn't necessarily final, because you then have the right to appeal that determination to the New York State Court of Appeals, which is the highest court in the state of New York, and they will review it, and they could contradict what the determination was. They could modify, they could sanction whatever they want to do in reference to their final determination. There's no such process that I know of in reference to the federal courts. And in my research, I think it came up that 66 different investigations have been made of federal judges over the years. There have been 15 removal processes by impeachment, and I think 7 or 8 went to conviction in the US Senate. Now, this is a great time if you're interested in political science, what we've been living through for the past few years. We've seen the nomination process with Judge Gorsuch and Judge Barrett, and the third judge, I forgot his name at this right now, that President Trump submitted. And we watched that review process to go through the Senate. And what's interesting is, as a political matter, Merrick Garland, who's been designated as President Biden's Attorney General, his name was submitted by President Obama to serve on the US Supreme Court. But the politics of it was such that it couldn't get through the Republican-controlled Senate. And as a result, the nomination for the open position waited until President Trump had the opportunity to appoint somebody. Interestingly, though, Merrick Garland, had he been appointed and served on the US Supreme Court, would have made 4 Jewish Supreme Court judges out of the 9 on the court, which would have been remarkable when you think about it. Nearly 50% of the highest court in the United States would have been would have had Jewish justices. An interesting, there's 2 courts that are applicable to New York State citizens where you don't have to be a lawyer. One is your local town judge or village judge does not have to be a lawyer, and the US Supreme Court does not have to be a lawyer. Now, I saw that there was a comment made by Ms. Adelman of justices, not judges. Is there a difference between a judge and a justice? And I'll give you a very quick story. A bunch of years ago, I used to sit as a Supreme Court judge down in Manhattan, and I befriended the Chief Judge of New York at the time. And we would talk about the role of the trial judges versus the appellate judges. And I pointed out to the Chief Judge that she had really never sat as a trial judge, and that at some point she might want to just sit as a trial judge, particularly on a serious criminal case, just to see what a trial judge has to do. We have to make these calls on technical evidence, which may or may not result in the further prosecution of the case. But you might have the victim's family sitting in the courtroom wondering what happened, that there was no justice for the deceased child that they lost because of a homicide. And I left the conversation off at that. About 6 months later, I was contacted by the Chief Judge, and she said, you've been thinking about how I pointed out to her the role the trial judge has. And she said, it was very interesting, and it's really affected my thinking. She said, what we expect from our trial judges is justice. And she then wanted to say, and leave the law to the appellate courts. It was a very interesting observation. Now, obviously, we have to be aware of the law and apply it as best we can. But there's something being in the courtroom, being hands-on, hearing the evidence, dealing with the people, that's a call for justice. And I myself, as a trial judge, or when I was a trial judge, always felt comfortable knowing that 5 appellate division judges would be reviewing what I was doing, and that 7 Court of Appeals judges would be reviewing the determination that the appellate courts would make of my rulings. So it would give me some flexibility to do justice. And that to me is what I've always perceived to be the mandate that we have. That's pretty much all I have to say on this. Oh, one thing I wanted to say. Judge Morris succeeded me as town justice. And when I was serving back in the 80s is when somebody came up with the idea of the roadblocks or the roadside checks for drunken drivers. And it looks like a great idea. You put a roadblock at a busy intersection, and anybody that goes through it, they open the window, they smell the alcohol in somebody's breath, they'll arrest them for the DWI. It seems like a really good system. Now, picture a roadblock at the 12 corners on Monroe Avenue. And particularly, and this is early on in the 80s when cell phones were first becoming prominent, word would get out and people would call their friends at given bars saying there's a roadblock, or a checkpoint, we'll call it, a checkpoint at the 12 corners. The result of that, when people would leave a bar on Monroe Avenue, instead of going to the 12 corners, they would go down Warrington, down Oakdale, down all the side streets. And as a result, we had the possibly intoxicated drivers diffusing into the neighborhoods, which is even worse than having them on the main highway. So that was a good idea that the reality of which was not such a good idea. And I don't know if they even do the checkpoints anymore. But with that, I'd like to turn it over to whoever has any questions for any of the 3 of us.
All right. Thank you, everybody. That was absolutely fascinating. I took notes. I was riveted. So we have a number of questions from the folks who are attending with us today, and I'll read the first one. and eager to hear your reactions to it. The first question is, does it not seem that there should be mandatory retirement ages and or term limits for the Supreme Court? It has become way too politicized, and an example is the current turn far to the right with many younger conservative judges. What are your thoughts?
Well, I was just retired because of my age. So I've been retired for must be 11 days now. I don't know that age is a necessary qualification or disqualification. In reference to the politics, my experience has been that the Republican versus Democrat and the conservative versus liberal, that straightens itself out over the years. And I happen to think that now I'm a Republican, that there's a tendency of conservatives to become more moderate. And I think historically I think John Paul Stevens was a conservative appointee who became very liberal on the bench. Whizzer White, who was I think a Kennedy appointee, was a liberal who became more moderate. I think it balances itself out pretty much, but that's a different issue than retiring people because of their age.
Well, and I think there's a difference between retiring because of age and term limits.
Yeah.
So, and I think you need to approach them differently. So age, I think that if the concept is that judges should represent society, then a lot of society is older and judges should. I think there's a tremendous amount of experience also. So the question becomes, to me, what does term limit mean? And it's really the same question in Congress to some extent, although there are limits in the presidency and in the judiciary. But the difficulty, if you have a term limit, is that you then don't necessarily have the as much protection. You don't have the independence. You don't necessarily have the ability to gain the benefit of significant and long experience. I'm actually not a fan of term limits, but my significant other is a big fan of term limits. I'd rather have people more involved in every aspect of government and have the ability to be able to vote people out if they're not doing their job. And then the question becomes, what does it mean to do your job? People have criticized Judge Clarence Thomas because he never asks any questions. But so who are we to necessarily judge that? Karen, you look like you want to say something desperately.
I do. I think that term limits for Supreme Court judges is a very interesting proposal. Our President-elect Biden has made it clear during his run that he was going to appoint a bipartisan commission to provide recommendations for reform of the U.S. court system. So we may see some interesting proposals. This was also an issue where in the Georgia race, Reverend Warnock was asked about whether he would want to pack the court, given its now conservative slant. That was that issue that Biden responded to as that he was going to set up this commission. And Reverend Warnock refused to answer the question about packing the courts, and his opponent predicted that he'd be pro-packing the court. It was an issue in that very important race and an issue in the presidential race. So I think that we could see some changes coming.
Okay, let me get on to our next question, which is there value to assess judges based on number or percentage of cases won or lost on appeal?
Oh, can I tackle that one first?
Please.
So years ago, I'm in the courtroom a lot, probably not as much as judges, but I'm in the courtroom a lot. And, you know, you always get upset when you think that somebody, when you ask a question, there's an objection and the objection is sustained or overruled or whatever it is. You have this pride of what you do, until somebody said to me and showed me some studies that show that judges are wrong at least half of the time, if not more. And then there are cases that are one side, let's say the plaintiff wins at the, and we'll do a state court case. Plaintiff wins at the Supreme Court level, defendant wins at the appellate division level, and the case goes up to the Court of Appeals in New York, and the plaintiff wins again. So who's right and who's wrong? So the answer to that is that I would never want to see anybody judged on the number or percentage of cases won or lost on appeal. And philosophies change. As I mentioned before, for 50 years, people who were trying to say that Title VII covered sexual orientation lost their cases. And then the United States Supreme Court interpreted the law differently and somebody else won.
Just to pick up on that. Oh, by the way, Sharon Stiller is, in my 26 years in the Supreme Court, nobody was better prepared than Sharon Stiller when she came.
Oh,
I mean,
well, I'm going to not say anything more. I'm going to turn my video off. Thank you.
I have to say that. I have to. It's absolutely true. Interestingly, it's almost mathematical. In civil cases, now we do civil and criminal, and I've done a lot of each. In civil cases, trial judges in this area get reversed or modified 1 out of 3 times. It goes to the appellate division. Okay, and in criminal cases, they get reversed or modified 1 out of 6 times. And the appellate division, from what I've heard, used to keep a scorecard up there. And when I was up for re-election a bunch of years ago, I asked if I could see my scorecard, and they sort of said that they didn't keep one. But I went and I reviewed all the cases I had, and it came out to be 33% and 16%. It's just how it works. And I think Sharon's right. If a judge is fearful about what the appellate division may do, I think that really puts a damper on what I referred to a few minutes ago as justice.
I agree. I think that Judge Ark's comments about justice really answered this question, that trial judges have to do justice. If I err, I'm happy, as Judge Ark, as you said, that there is a appeal process to correct. I certainly wouldn't want anybody to be harmed by an incorrect decision. But you make the best decision that you can at the time. If as a judge you need a moment or more than a moment to rethink and assess and maybe do a little research right on the spot, then you take that time, you take a short recess, you do what you need to do, and make the decision. So you're always working to make the best decision that you can at the time.
A few weeks ago, they had a nice, when I was retiring, the judges had a ceremony, or not a ceremony, just a presentation that they presented me with. And so there are some appellate divisions there. And I said, you know, the issue always comes up to, what effect does it have when we get reversed by the appellate division? And I said, usually it's a couple of years after we tried the case, and it's like getting a final paper back when you're in college and the grade really didn't mean much to you because you knew you were going to graduate, and you sort of look at it, you sort of remember what you did, but you don't really care. But it's more interesting than it's just an interesting thing to see what somebody else thought of your work. I said, so it doesn't really bother me with the appellate division. And so the judges, the appellate division judges sort of gave me a quizzical look. And then I pointed out to them, I said, however, it does feel good when they reverse me and it goes to the Court of Appeals, and then they get reversed by the Court of Appeals and my decisions reinstated. So, but it can't, it really, you want to follow the law the best you can, but you rely on the appellate division to straighten that out if there's a problem. By the way, particularly in the criminal cases, in the middle of a murder trial, the evidentiary rulings come in really fast, and you have to make a decision as a jury scene. You have to make a decision, an evidentiary decision. Judge Morris has been in that position in court, and you just have to do the best you can. And cases get reversed on an evidentiary issue during the course of the trial. And like I said, you do the best you can. That's why we have appellate courts. And that, by the way, the appellate process is a strength of our system. It's a real strength of our system.
Thank you so much. All right, we have another question that relates closely to the question that came in right after it and touches on something that Judge Ark, that you mentioned. The question is, should judges have a political affiliation? And someone else added, I feel Supreme Court justices should have equal numbers of liberals and conservatives. It seemed unfair that the Honorable Ruth Bader Ginsburg was replaced by Amy Coney Barrett. What are your thoughts about it?
As I said before, so we've had Republican, Democrat as presidents, and so you get a mix in there. And I'll tell you something, you put 9 judges in a room, they're not going to agree on anything, or they're going to all have their own opinions. And that's what moderates it. And I look at, I'm a centrist. I like everything flowing to the center. I think it balances itself out. But there's no injustice in that Gorsuch succeeded Ruth Bader Ginsburg. I mean, it's not, nobody owns those seats. We're, as judges, we're renting our spot on the bench. We don't own those spots on the bench. And I mean, I was a Republican, and Judge Karen Morris is a Democrat. I was there 14 years, and she's been there 26 years. And who succeeds her, we don't know. But I don't, particularly at a trial level, it's so evident and so specific to the case that's before you that you really, a philosophic thing doesn't play into it. Just to give you an example, back in the 80s, there were pro-life, anti-abortion protesters that were picketing in Brighton, and they got arrested, and they were brought before me, and on the face of it, I ran as a Republican conservative, and I think as it turned out, I was the first judge in New York State to put these protesters in jail, my reasoning for it had nothing to do with any view of what my view would be pro-life or pro-choice or anything. It had to do with the fact that they refused to give me their name when I arraigned them. When I was arraigning, they'd come up and I say, what's your name? Baby Jane Doe, Baby John Doe, whatever. I said, look, I'm going to tell you right now, if you don't give me your name, you're going to have to be sent down to jail, because if some young kid got arrested from the city and he made up a name and the police told me it was a made up name, I couldn't release him, and I can't release you. And so they went and hugged and came back. I said, okay, now do you want to tell me your name? They went through the same thing. So I think I put 33 of them in jail. It became a big brouhaha. And for the next 4 or 5 years, whenever I went any place, there were pickets out there with protesters calling me baby killer or whatever, which had nothing to do with the determination. So, I mean, you do the best you can.
I think that it's important that judges those who are elected run on a party line. And here's why. As I explained, the judges' values find their way into our law. And judges, when they run for election, candidates for judgeships cannot discuss their positions on disputed legal or political issues. And this is because those issues might come before the judge, and we want the judge to have an open mind when he or she addresses these issues. So as a voter, you don't have a lot to assess the candidate, the political affiliation tells you something about where that person is coming from, what values they're going to bring to the job. And let me just follow up from what John said. We're both Brighton judges, and there was a doctor who performed abortions in the town of Brighton. I also had a issue involving the protests. In the case I had, the issue involved a signage ordinance in the town of Brighton. So the protesters had a sign that exceeded the permissible signage in by ordinance in the town of Brighton. They claim they were ticketed for that. They said the statute that limited the size of the sign violated their free speech. So now the question is, did the town have sufficient reason, a rational basis for limiting the free speech in this particular case? Different judges with different values maybe would have decided that differently. I decided that the signage that was permitted was sufficiently large that anybody could get their view across, and also that the town had good reason for limiting the size of the sign in order not to be unduly distracting to motorists. This was the one case in 26 years that came out of Brighton Court that I presided over that might have made it to the United States Supreme Court. It costs money and takes a lot of time. There's like 3 or 4 appeals before it goes up to the US Supreme Court. And this group was very motivated because of the abortion involvement to get a different ruling, knowing that the ruling was going to be precedent in other towns and other locations. But the case all the way up in each appeal, sometimes there's one judge, sometimes 3, 5, or 7, and every judge all the way up in 3 or 4 appeals agreed with my decision. When that happens, the US Supreme Court, which is a very busy court, won't take the case because they want to take cases where there's disagreement in the law so that they can resolve that the disagreements in the law. So it didn't make it to the US Supreme Court. But to go back to the basic question, I think that running on party line for judges is important and gives the people, the voters, an indication of the values that judge is going to bring to the table.
Can I just do one quick comment, which is that I don't think the question is running on a party line. I'm not necessarily in favor of that. I think the issue that Karen points out, that Judge Morris points out, is that we don't know enough about our judges. We don't pay enough attention to their decisions. We don't go into court to watch them like they did in the olden days. And I think it's a shame that we need to have political parties to tell us, to give us some information about the judges. We really should know more.
Thank you so much, everyone, for amazingly insightful comments. And thank you to our audience for some great questions as well. We are out of time for this evening's IdeaFest, but I want to say how appreciative we are to our 3 esteemed panelists and to you out there in the virtual world. Thank you for tuning in. If you have additional questions that you weren't able to ask during this hour, please feel free to email them to us and we will pass them along. You can send that email to mcataldi@jccrochester.org, and that email address is in the chat if you would like to cut and paste it. So again, thank you all for joining us this evening. Take care.